Hello! This video recording is going to take an in-depth look at the types of defenses that can be used in a court of law by a defendant. We'll mostly focus on different types of excuse defenses and when they can and cannot be used. Today's quote that we're going to start off thinking about is by Plato, an ancient philosopher who studied under Socrates. And in this quote, Plato says, "Good people do not need laws to tell them to act responsibly, while bad people will find a way around the laws." Take a moment to think about any examples of a good person or a bad person, and what did they do? You may use this as an opportunity to pause this video to contemplate the question. Again, this video is going to review different types of defenses, and we're going to take an in-depth look as to when certain defenses can and cannot be used against specific types of crimes and charges. Let's start off with duress. Duress can be used as a defense in the case of arson, kidnapping, robbery, burglary, and felony murder. Of course, we know, as we learned in the previous chapter, that felony murder is different from murder in the first and second degrees. It can only be used in felony murder if it negates the underlying felony. And I'm going to give an example of this in just a moment and what that means. One thing I want to emphasize, two types of defense that cannot be used against a murder charge, first or second degree, is duress and necessity. You cannot use those whatsoever as a defense to murder. So if Johnny holds a gun to Susie's head and says, "Kill Jackie or I'll kill you," she cannot use that as an excuse to kill Jackie. Now, let's look at arson to start with. Arson is when you intentionally set something ablaze with a fire. Kidnapping does not just have to be children, of course. It is possible to kidnap adults, just to clarify. Robbery, the threat of violence. Burglary, breaking into a building. And felony murder, when a murder occurs during the act of a felony. So I'm going to combine some of these two to give an example of when felony murder can be used, when a felony murder charge can be defended by a duress defense. So Johnny and Susie are playing in an abandoned house. And Johnny says to her, "Set this house ablaze or I'm going to kill you." The act of arson is already a felony. So in order to defend her own life, she complies and she sets the house afire. Now, what she does not know is that there's someone else in the house. So she did not intend to kill the person. So she sets the fire, and the other person, unbeknownst to her, gets killed in the act. Now, this is a felony murder. However, she was under duress. Johnny directly threatened her and said, "If you don't set this house afire, then I'm going to kill you." So felony murder is only if it negates the underlying felony. We have to go back to the previous lessons on intent. If she did not intend to kill the other person in the building that she was setting on fire because she was forced to set it on fire, then duress can be used. If she knew the other person was there, then that's a different scenario. Intoxication defense. It can be used if it negates a requirement element of the crime. Remember, we went over elements of a crime in the previous unit. There are 4 elements to the crime. Now, you can either have voluntary or involuntary intoxication. Voluntary meaning that you purposely took the drugs or the alcohol. Involuntarily means that someone spiked your beverage or you were unaware that you were taking the drug. Now, one thing we have to consider is, again, intent. We're using and building information from the previous chapter here. Voluntary intoxication cannot be used as a defense for a rape charge. Doesn't make sense, okay? Voluntary intoxication can be used if the person had two specific thoughts. One, they thought they had consent, and two, they did not meet the requirement of intent. Again, this is referring back to the information found in the previous chapter. These are things to consider when looking at using an intoxication defense in a court of law, more specifically against a case of sexual assault. Okay. Now, in an intoxication defense, there might be specific intent. The intoxication occurs before the defendant has formed the intent, or the defendant, this by the way is the abbreviation for defendant, can use that to reduce the charge as a lesser charge without specific intent as part of the elements of the crime. Again, this all goes back to what we went in the previous chapter. And for those of you that want the page number, we're looking at page 10 from chapter 1. Defenses where the criminal act that was committed was considered justifiable or excusable is self-defense, defense of property, or defense of others. Right? So in those particular cases, if it comes down to saving your own life or someone else's, these defenses can be used in a court of law. Other defenses where the act was committed but you're not criminally responsible is something known as infancy, intoxication, insanity, entrapment, duress, and necessity. Again, the book goes over these things, so you can look for more specific examples there. Now, in order for self-defense to be claimed, 3 things must be established, and if these 3 things are not there, then you might not be able to use self-defense. Number 1, you reasonably believe that the force was required for your own protection. Threatened harm was bound to happen or about to happen, and the attacker was willing and able to injure you, also known as imminent danger, immediate danger. And the force used in self-defense was reasonable. It wasn't over the top. So if you're defending yourself, maybe you punch the person who's attacking you in the face to get away, right? Deadly force is another issue. 2 things must be established. In order to be able to use deadly force on a perpetrator, you must establish the fact that the attacker was going to kill you and or inflict bodily harm, and that the deadly force was the only way of preventing the perpetrator from committing the crime that they were about to commit. So let's say someone breaks into your home and they're going to physically hurt you. Maybe then you would use deadly force. You obviously can't run away. Next, we have something called the Statute of Limitations. In the previous video, I didn't go over this, but I'm going to go over this now. This is neither a justification excuse, nor is it a defense, an excuse defense. This prohibits or bars the prosecution of criminal defendants if the legal action starts too long after the commission of a crime. Limitation periods based on the crime and the jurisdiction, although there's no statute of limitations on murder. And the passage of time may obscure evidence and witness testimonies as they fade into memory. So let me give you an example. And this is a hypothetical example, but in some states, again, hypothetical situation, totally made up. Connecticut has a statute of limitation of 7 years on sexual assault. That means that you have 7 years, if you were sexually assaulted, to file the charges. And if you don't find the perpetrator in 7 years, then you'll never be able to press charges against that person, even if you find them 7 years and 1 day later. So there's a limitation of time that you were allowed to press charges. Again, that was just an example. Limitations on misdemeanors, depending on the state, are usually 2 to 3 years. Limitations on felonies could be anywhere from 6 to 10 years, like sexual assault and robbery. Some jurisdictions do not have any limitations for serious felony. And again, there is no limitation on murder anywhere. Some reasons for limitation is fairness, obscured evidence, meaning over time, even some forms of DNA evidence, not all, just some forms of DNA evidence can deteriorate, especially if the DNA has been exposed to mold. And then, of course, eyewitnesses are not reliable as it is, but add in the passage of years, and it makes it harder for them to remember maybe even important details. The statute of limitations, however, can, in some scenarios, in some districts or jurisdictions, areas of control, in two different types of scenarios. In some states, if the person leaves the state where the crime has been occurred, it puts a stop on the time, especially if the charge is brought against the defendant within the time period. So let's go back to our previous example. You have 7 years to file a lawsuit. And in that 7 years, you file the complaint, but the person leaves. They leave the state and they go across the country. That charge is still there despite the fact that they're gone. And when they return, the time starts up again. So let's say the person flees a year into the 7 years. Time is stopped. You still have 6 years left. They return to the state of the crime, and that's when the time picks up again. Now, something to understand, DNA evidence does not fade over time unless it's exposed to extreme conditions. So as long as it's properly preserved, it'll be fine. Eyewitness accounts, however, do. DNA, however, is considered reliable many years after the crime, again, assuming there's no degradation that occurs. This concludes the in-depth look of when certain types of defenses can be used in a court of law.